Happy Tuesday, and welcome to another episode of Let's Start Justice with Jamaicans for Justice team. My name is Michael Jackson, Executive Director of JFJ.
And I'm Jade Williams, Policy and Advocacy Specialist at JFJ.
Now, you see, even though we're tired and we're a little bit version of what Jamaicans will call pop down, we can't ever let the listeners know, but we're happy to be here. For those who follow us on our social media platforms, you're aware that we're just coming from Gordon House, where we made our presentation before the Joint Select Committee reviewing 3 pieces of legislation. Simply put, these pieces of legislation, they're focusing on mandatory minimum. So I don't think we will ventilate fully, but we know that JFJ, we don't support the mandatory minimums at this excessive level.
Yes, absolutely. But also, if you are interested in our position, we do have several previous episodes, one of them entitled Mandatory Minimums,
yes,
that talks about that. But feel free to watch our presentation, definitely.
On PBC, it's there. I think we may have to get permission from PBC to pull aspects of it. Mm-hmm. But what I'm heartened by, Jade, is that the members were quite receptive.
Yes.
To a number of the proposals. So we're happy for that, and we look forward to the matrix reporting in terms of what they would have accepted from the different presentations over the past week. So we're happy.
Yes.
The traffic was bad this morning, though.
And continued to be bad throughout the day.
Yeah. All right, human rights recap of the week. But before we get into it, last week we were before the house. Jade was out ill, and I was supported by, I can't remember his name now.
I remember his name. It is
Noel
Lewin Jr., one of our young professional advocates, one of our young
I remember
members.
The first name, yes, Noel.
Yes.
Bright, young first-year law student, yes. Brilliant future ahead, quite engaged. So we're happy to have Noel on board with us here at JFJ, and the others who are a part of the advocates membership group that JFJ is looking to strengthen and forge ahead. So that was quite good. And today our topic is focusing on whistleblowing as a continuation of the advocacy efforts, but more so just encouraging people that when you see acts of corruption and other issues, that you make a report, but be so guided by the contents of the law. But before we get into the topic, just to discuss some things that happened in the news cycle last week. Chief Justice Ryan Sykes, let us put on a record our congratulations to the judiciary on getting rid of the backlog, the court backlog, because we know that it has far-reaching implications in the administration of justice. When you have court backlogs, you're talking about matters taking longer periods to be dispensed of within the justice system. So that's a commendable achievement. And by the way, it's just at the parish courts. Chief Justice Sykes, he set his goal, his target in 2019, and he achieved it 2 years ahead of schedule. So again, big up Chief Justice Sykes. We said it a few episodes ago, I remember. But he also cautioned that while the higher courts have seen some improvement, it needs a little bit more time to get it where it needs to go, which is why, again, our caution to the Joint Select Committee on the mandatory minimums and their potential impact. We hope that they take those things into consideration. Another thing, Jane, I'm not sure if you saw a statement from the Office of the Children's Advocate that indicated, Diane Gordon Harrison indicated that an anti-sexual guide handbook of sort is going to be developed by her office, really to help parents to look at some questionable activities that may, be stemming from neighbors, those within the household, preventing the high occurrence of sexual violence with our children, how to ensure that they provide guidance to those who are online and so on. So Children's Advocate, big move. We look forward to that, and JFJ will certainly support if and so needed, whether in promotion, review, whatever support the office may need. We stand ready because it is a commendable effort again. So lastly, another thing that came out last week, Jade, listeners, and I think stemming from a caution that one of the law enforcement officers made about the high levels of sexual offenses coming down from Trelawney, Saint and Side. And listening to DPP Paula Llewellyn this morning on a radio program, she indicated that the number of committal hearings that she has, sexual offenses apparently far exceed murder. I don't want to misquote her, but it's along that line where the levels of sexual offenses, it's alarming to her, and it sends a signal whether it's more happening or more reporting or more matters being brought before the courts. But either way, when you look at those alarming figures, as the DPP cautioned, it really is something for us as a society to look into. So those were some of the main things happening. I'm not sure if we missed anything that you can recall.
No, I don't think we missed anything significant. But I do want to add that I appreciate the public defense. My apologies. The DPP, the Children's Advocate.
Okay.
That effort is, I think, because we have focused so much on solving what are, yes, they're criminal issues, but criminal issues tend to stem from social problems. And I appreciate that the Children's Advocate has taken the approach, instead of making another legislative proposal to mitigate sexual violence, is addressing it from a social standpoint that could perhaps be more effective.
Absolutely. And the DPP also called for these things. Parental support, parents being trained. And on this program, we also had it.
Yes.
If you remember Dr. Warren Thompson from the CPFSA, we had him on. And we had State Minister at the time, Juliet Cuthbert Flynn, and members from law enforcement as well, that spoke to these issues, the importance of parents being aware. Don't leave your children with stranger. And even then, within the context of the home, we must be aware and cognizant of the potential dangers that may very well arise. So, again, I agree. Big move from Diane, Children's Advocate. We support it.
Absolutely. So we'll go straight into our right of the day, which today is more of a did you know, and in keeping with our topic, we pulled section 15 from the Protected Disclosure Act, which is what we made our representation on in Parliament last week. And that section speaks to immunity. So where it is that a person makes a protected disclosure, or receives or investigates or otherwise deals with a protected disclosure, they are not liable for civil or criminal proceedings or any disciplinary proceeding by reason of having interacted with, whether that's investigated, made, received, that disclosure in accordance with the Act. Now, through our discussion, we'll talk about what in accordance with the Act means, and how well this section can be applied considering the other sections of the Act. And we'll go straight into our trivia question for the week, which is, which year marked the inception of the Witness Protection Program in Jamaica? Now, this is not the Protected Disclosure Act. This is the Witness Protection Program generally. So when did it start? When can you trace its inception?
Not the law, the program itself.
The program itself.
Okay. I just seeking clarification for the usual winners.
Yes.
So they're so guided.
So we look forward to your answers, and you can respond on our social media pages, or you can send us a WhatsApp at 2397583. So this week we are talking about the Protected Disclosure Act, blowing the whistle on corruption and human rights violations, and understanding those provisions and protections that are related to whistleblowing. Now, whistleblowing in Jamaica is a pivotal instrument in unveiling and rectifying instances of corruption, misconduct, and transgressions across diverse sectors of society. It entails individuals, often insiders or employees, exhibiting remarkable courage in coming forward to expose illegal or immoral or reprehensible activities. And these whistleblowers play a pivotal role in unearthing cases of fraud, mismanagement, and other forms of malfeasance, and contribute to the overarching objective of fortifying governance and upholding integrity in our national institutions.
Now, while the enactment of the Protected Disclosure Act of 2011 marks a significant stride towards safeguarding whistleblowers, and by the way, just to insert here, Jamaica is one of the first CARICOM countries to actually have this piece of legislation. So again, kudos to our Parliament. Nevertheless, it has been met with critiques for its perceived inadequacy. inadequacy, my apologies. Notably, the Act extends protection primarily against occupational repercussions. In other words, only within occupational setting you may find that you get some sort of protection, and we're going to be talking about that. But we recognize as well that people who blow the whistle on corruption and other maladministration may face other harm, other detriment. So that's one of the issues that we have flagged, especially in a culture often characterized by the omniscience adage, in forma fide culture. Moreover, access to the Witness Protection Program is contingent on a whistleblower's intention to testify in criminal trial, a condition fraught with its own set of challenges.
Now, unfortunately, the Act does not consider provisions for the safeguarding of a whistleblower's family or loved ones. And in light of this, there are also currently no mechanisms for anonymous reporting detailed in the Act. So unfortunately, this is a potential deterrent to those persons who have critical information, from deterring them from coming forward. So the one other issue with the Act is that it does not recognize human rights violations in particular as a reportable improper action, and thus it leaves whistleblowers exposed in those cases where they report on a human rights violation.
Now, as we said at the start of the program, last week JFJ made a presentation before the Joint Select Committee, National Integrity Action, NIA, who will be represented by its Principal Director, Attorney at Law Daniel Archer. We also have President of the Jamaica Employers Federation joining us, David Wan, and he was with us last week before the Joint Select Committee. And I want to place here on record, just for the purposes of our listeners, several recommendations were made, and I should say the Joint Select Committee was receptive to a number of them. And JFJ, we have been invited to go back before the Joint Select Committee at its next sitting to finish our presentation. So just want to put that in context before we bring in our guests, just for the purposes of our listeners. Do we have both guests online?
We have Archer.
Miss Archer?
Yes.
Hello.
Hi, good afternoon, Daniel. Mikkel and Jade here. Thanks again for joining us.
Pleasure is always mine.
All right. At the start of the program, we outlined just a sense of what were the main issues and a little bit of history on the Protected Disclosure Act. But before we get into the fulsome discussion, I know NIA would have made its own presentation before the Joint Select Committee. So if we could start from there, where NIA stands with the Protected Disclosure Act and just its importance as a piece of legislation.
Well, we have consistently said, Michaela, that the legislation is well written in the context of the experience of the Caribbean. It's a very good part of the corruption framework. One of the things that NIA has been asking for, though, is to incentivize the system. And we say that on the basis that in the same way that you encourage people to utilize the Crime Stop procedures, that you would incentivize them so that they can utilize the protected disclosure, which is underutilized at this moment. And it may very well be so for the second reason, that there is not adequate or sufficient public education on the importance and how the legislation can be used. So those are two areas that we have been asking for. And the third area we have been asking for some attention is the reporting period. You will note that it gives the window of reporting. In other words, it says, well, you can't victimize against somebody from the date that they made the report. But you and I will appreciate that victimization can come a year, 2 years after. And the sexual offences legislation, it actually gives you a 6-year window. So we're asking for in the context.
The sexual harassment, Daniel.
Yes, sexual harassment. That is correct. My apologies. We'd have the same window of opportunity when you speak about this particular piece of legislation. So there is our window wherein there is some kind of protection. I heard you mention earlier the fact that persons are required under the legislation to give their name and address and occupation we do think that's a hindrance to utilizing the legislation. To be real, who is going to call against an activity in the public service and say, my name is Daniel Archer, I'm an attorney at law and I'm making this report? The fear of doing so may very well prevent people from making this report. And one of the other areas that the NIA has been asking for some attention to be given to is the Official Secret Act that was born from before you and I in Jamaica came into being.
Yes.
And it is still on the books. And it is still and has been used by different individuals when it suits them to quiet public servants. Mm-hmm. That cannot be the case if it is that you have a Protected Disclosures Act in play.
Pause that first, Daniel. We're upon a break. We're behind, actually. And we have Mr. David One on the call with us. So we take the break and we continue.
Welcome back to Let's Talk Justice. We are discussing blowing the whistle on corruption and human rights violations, and we're breaking down some of the provisions from the Protected Disclosure Act. We are joined by Daniel Archer, the Principal Director at NIA, as well as Mr. David One, the President of the Jamaica Employers Federation. I know we're talking to you before the break, Daniel, but I just wanted to give Mr. One a chance to share a little bit about the Jeff's submission and their recommendations as it relates to our whistleblowing framework in Jamaica.
Hello.
Hi, Mr. One. How are you?
Yeah, man. Great. So, what's the question? To be the submission we made to the Joint Select Committee.
Yes, what are some of your major recommendations?
All right. There's a list of persons who you can make authorized disclosures to. And we proposed expanding that to include persons like Commissioner of Customs, Chairman of the Port Authority, Chairman of the Police Services Commission, Chairman of National Works Agency, among others, because it felt like the more avenues people have to make a disclosure, the bigger chance you'd have of disclosures being made. So, for example, on the Police Services Commission, we felt like even though the police commissioner is a named person on the original list, if there is, say, fraud or anything corrupt going on at the highest levels of the police force, such person who want to make a disclosure may feel better going to the Police Service Commission than the police commissioner, as an example. So we recommended some additions to the list of persons to whom you can make a protected disclosure. That's one. Another modification we suggested was that there's this thing called, I don't have the paper in front of me, where we assume that there's, so I soon tell you the name that what we did.
And while Mr. One is looking for that information, for our listeners, just to put in context that the Protected Disclosure Act, it outlines in the legislation a definition called improper conduct, and we're going to be highlighting those issues. So, for example, fraud, mismanagement, unfair discrimination on the basis of gender,
race, place of origin, social class, color, religion, political opinions, a criminal offense.
Yes. And we heard from the Office of the Services Commission, for example, the need to broaden that in scope to ensure that it fully captures all the areas within which one could possibly be discriminated against. When you look at all of those possibilities of improper conduct now, the legislation also highlights what we call prescribed authorities, that people, workers within the public service, if it is that you see any evidence of these improper conduct, then you can go to the individual who you believe best suited to receive that information. And then if, in your estimation, there is need perhaps to escalate it or go directly to the Integrity Commission, who is the designated authority, you can so do it. We have a recommendation around that as well, but I just wanted to plug that for the listeners while Mr. One look for the info.
Thank you. Thank you. And one of the other recommendations we made was that you're now able to make a protected disclosure about an employer or an employee. And we had suggested expanding that to include subcontractors to the company and potential subcontractors, meaning those who are in the bidding process. So if you see anything going on that you think is, untoward, corrupt, etc., to somebody who's bidding to be a contractor, you could also make that protected disclosure. As well, suppliers to the agency or the company, we feel like you should be able to make a protected disclosure to anybody who's supplying goods and services to the entity.
Yes.
That was another recommendation that we made. We also recommended a toll-free hotline to be available, manned by a neutral party that's neither government nor attached to any agency or, institution, but a privately contracted party to man this hotline, and so that protected disclosure can be made anonymously to this toll-free hotline. That's another suggestion we made. And there's one other we made, but I'm going to have to look at it, where it assumes that if an employer discharges someone right close to when they make a protected disclosure, it is assumed that this is done vindictively by the employer. There's a term that's used. I can't remember the exact term now, but we are uncomfortable with that because we feel there can be abuse of that provision. For example, if someone is not performing their job properly and they know that they're going to get a bad performance review, etc., and probably on their way out, we feel that some persons may go and make a protected disclosure, a frivolous type of one, and use it so that the employer would have to halt the disciplinary process and stop this whole procedure because the employer is then assumed to be doing it vindictively because of this protected disclosure that's made.
And thanks, Mr. Wan. I want to bring in back Daniel here, and before I do, just to mention that the Protected Disclosure Act, it does have provision for malicious reporting. That's one. And then there is almost an onus on the employer to prove that any disciplinary action is not as a result of whatever disclosure such employee perhaps would have made before. And I know, Daniel, yes, going back to a point that Ms. Archer had made earlier about that possible 6-year time frame. If you could just reiterate that position, Daniel, for us.
Not a problem. What we are saying is that the legislation speaks to what happens at the point of reporting. It doesn't protect a period. It doesn't give a period of protection for reporting. And it's important to have that because you'll appreciate that discrimination or steps taken to punish you because of what you have said can occur after the report has been made, a year, 2 years after. And so we're suggesting that in the same way you have that period of protection in the sexual harassment legislation, you'd have that period of protection in this legislation, and the suggested period is, of course, the 6 years. I want to reiterate, though, Michaela, that the whole notion of making a report is good faith and in the public interest. Good faith must be done in good faith and must be done in the public interest. And there are provisions if it's not done in good faith and it's not done in the public interest. Those are things I think are important because you want to also balance the observations made by the employers as well as ensure that there is adequate room to facilitate or encourage persons to make these reports.
Thank you, Daniel. As you mentioned that point about good faith, I think when we talk about public interest, there is a kind of an established gauge as to what might be in the public interest. But good faith seems to be a more subjective kind of demarco. I don't know what NIA's opinion on that is. Yes, what do you think about the good
Well,
faith
perhaps
being
because
included in the
I
act?
am also an attorney. Good faith is now going to be looking at what's your motive. And there is authority and legislation that will support what that is. So is it made in good faith? So when we have a complaint being made because I know I'm going to be fired, is that good faith?
But and again, I ask, what is your opinion on whether or not that undermines the objective of the act?
Good faith, I think, in respect of the act, and I speak from my position now as Danielle. I have known confirmation of NIA's position on the whole notion of good faith. So I speak to you as Danielle, the attorney, who can argue that good faith can be both objective and both subjective. Good faith is objective when we can look at the surrounding circumstances and make a determination that I'm not making this report against you, Jade, in the context of good faith. I'm doing it because I have an interest to serve. I have a mission. There's something that I want to get. There's a motive that is not supported by reason or reasonability. Subjectiveness may come in, of course, by looking at, well, as whether the faith measures up to what I'm doing for myself or whether I'm doing it for others. Or what is the motivation, I think it comes down to. Ultimately, what is the motivation for making that complaint? And that, of course, if you look at the legislation, it does foresee that there is going to be some discussion around that, and that is why I think it has that avenue. But because you have raised the question so eloquently, it is reasonable to expect that perhaps we could look at putting in what are called a criteria to establish how good faith can be proved in this instance. Because it may very well be that given the nature and the purpose of this act, what the mischief that is to be cured by the legislation, that we want to be very clear and not very argumentative as to what good faith is. That's my view.
We want to pick up that point, but we're upon the break. We're actually a minute behind. So we take the break. Please stay with us. Welcome back to Let's Start Justice. We're talking whistleblowing on corruption, human rights violations, and other provisions within the Protected Disclosure Act. We're joined by Danielle Archer, Principal Director and Attorney at Law from the NIA, and Mr. David Wan, President of the Jamaica Employers Federation. Before the break, just to put in context the matter of good faith and public interest, it's one of the critical underpinnings of the Protected Disclosure Act. So I'm really encouraging listeners to go and read the legislation. Section 5, I believe, that is where good faith and public interest outlines that as one of the qualifier to even receive protection under the law, then whatever disclosure is made must be done in the public's interest and in good faith. I know you perhaps, Daniel, may need, and I know NIA perhaps, you don't have a position on it as an organization, but I would ask, and we can speak off air on this, because listening, JFJ, we had a view on it. Listening to the Integrity Commission as well, they actually asked for a definition to be included in the law, because when you look at even incentivized reporting, and looking at other countries, one of the concerns we had in terms of the good faith criteria, whether or not someone who is motivated by money could so qualify to receive the protection. So it's a little bit nuanced. Last week when we made our presentation, there was mixed views on this. I remember, Mr. Wan, if you recall, member Malahu Fort had pushed back a little bit, and within her right and respectfully so, to indicate that you must have some value system in the legislation where you really want to motivate people to act in a way that is really service above self concept, and we agree, but that's in the ideal world, because sometimes we blow the whistle based on things that we experience in our self-interest. So we had pushed back a little bit with a counter view on it. Others had supported the incentivized reporting, Daniel, but they indicated that maybe it's not best to put it in law, but to maybe leave it up to the Integrity Commission to think it through a little bit. So I just wanted to put that.
When we don't put it into law now, we get into a position where we start to argue, is it lawful?
Yes.
Is it within their discretion? And I think to be clear, since we're looking to advance the legislation, that you are correct to set a criteria that allows one to make a decision as to whether it fulfills the expectations of a report. I'll go further. If it is that we are of the view that incentivizing the reports under the legislation are something that can be exploited, we can have an assessment of the extent to which, let us not jump from our heel point and say this is going to be abused. Let's get the facts. The behavioral model would suggest that you would take an assessment of the people who are most likely to make a report and inquire whether or not it is motivated by financing. Are the reports to Crime Stop motivated by financing? They offer an incentive, and what we are asking for under the protective disclosures when we say incentivize is simply to say to people, hey, just like how you give a tip, and I think Mr. Wan is onto something when he says to have a tip line. That is something NIA has supported. If it's anonymous, what's going to be the motivation? If it is that it can't be proved. So look at Crime Stop. You will appreciate that the tips are only paid out when the report that is received is of value.
Yes.
It's built into the system. Nothing precludes us from having an incentivized system wherein these quote unquote value expectations are built in. Is the report true? Are the elements of the report true? Are all the elements true? Is this person working there? Are they saying it so by hearsay? Can we verify that which has been said? Do they come with documentation? All of these things can reasonably be done. But we must appreciate that given your behavioral model, there has to be some incentivization for people to act. Whether it is by saying that we're going to be waiving all fees and fines under the traffic system, or is it that we're saying to people when you're coming in to make your reports, they won't charge you a late fee?
Yes.
Everything in this country has something attached to encourage people to do something that's right for themselves, and even more so, that is right for the nation. This legislation is no different.
Yes.
Yes.
Jade, I know you wanted to ask a question of Mr. Wan, but if you could just permit me, there's something that Mr. Wan said earlier in terms of broadening the scope on who you can make a disclosure about.
He said two.
No, not the two in the prescribed, but in terms of the supplier so on.
Yes, right.
So, Mr. Wan, my question to you is this. One of the recommendations made by JFJ, when you read the current Protected Disclosure Act, well, the act itself, it's current. It provides for occupational detriment. So, for example, preventing someone from facing the possibility of disciplinary proceedings against them and so on. We made the recommendation to broaden it in scope beyond the occupational setting, but also whether or not harm may come to someone outside of the workplace. I'm not sure if Jeff considered anything around that that you could speak to.
Let me see if I understand what you're saying. You're saying that somebody who's outside of the workplace, who is not directly connected to the protected disclosure reporting, could be harmed? Is that what you're saying?
Well, that's another side of it. But I'm saying the person who makes the disclosure, the employee, right now the law only protects them from occupational detriment. So in other words, if harm were to come to you outside of the workplace or to even your family member, outside of the workplace, there's no protection, and there's no protection for your family member.
No, we didn't take that into consideration.
Okay.
And it's a very valid point. I think maybe it should be extended, that kind of protection to immediate family members of the person making the disclosure. That's a very valid point. We didn't think about that.
All right. Thank you so much. Daniel, you had any thoughts on that?
Looking at that, if you look at how it's done under imitating the system of Crime Stop,
yes,
these are things that are built into the system. That's what gives the system confidence. That's what gives the system trust. So when we make the suggestion that I use a system that's identical to Crime Stop, that's what we're thinking about. Incentivizing, protecting, ensuring that whatever is required to ensure that that person is available to give information of value that's in the public trust built on good faith, that we do the necessaries. So if we're going to incentivize, we're going to remove the requirement to have your name and occupation and address noted, then I think if we're going to use that identical system, it's built in. It's almost a given that you're going to create within that system some kind of protection that facilitates not just the person who's making the report now, but remember, if that person makes a report, it may very well be they have witnesses.
Yes.
And so, if that's what I'm saying, build in the system the things that we have learned and benefited from the crime stop system. It's no different. The big difference is that this is now marked by a well-written legislation at the time, because it's now 13 years old, I think. And as time progresses, things change and things improve, and some things we need to tighten up on. And these are the lessons that we're now learning in terms of looking at the legislation and wanting to make it work. The recommendations, I think, have been put forward by Jeff, by JFFJ, as well as NIA, are all valid. And I'm heartened by the reality that the Joint Select Committee is actually listening and contemplating these recommendations.
Yes, I think one of the reasons that we really made that recommendation as well is that improper conduct does contemplate a criminal offense as one of the conducts that can be reported on, and you know how that can be regarded. I think in the write-up we said in form of dead culture. So.
And I think two other presenters utilize that same language.
Yes. So it is a major consideration for, because even as we talk about incentivizing, we simultaneously have to talk about motivation, and I think that is one of those things. And as we talk about motivation, I would throw it back to Mr. Wan to ask, what do you think that, one, we have done sufficient public education on the provisions of this act and its implications? Is there room for more, and would that assist in our motivations to make reports or make protected disclosures as the act contemplates?
Yes, I don't think nearly enough has been done to publicize and to promote this. As with several other pieces of legislation, too, for example, the flexible working arrangements.
Yes.
I don't think enough has been done to publicize that, so it gets better utilization. The short answer is no, I don't think we've done enough to publicize it and, inform the public some more about what's in this bill.
Yeah, thanks. And I mean, to be fair to the Integrity Commission, they're a new body. They became operational 2018 following the law coming into effect. But I see them doing social media posts and so on blowing the whistle. But I would encourage the Integrity Commission to broaden the scope of what you're encouraging people to blow the whistle on. So, for example, within their remit as Integrity Commission, they say blow the whistle on corruption. Very, very important. But we go back to what improper conduct entails. And Daniel, I know Prof, when he was before the Joint Select Committee, I think he spent a good 10 minutes on this need, for public education. So if you could just articulate NIA's,
Critical. You can't have legislation and people don't know what the point of the legislation is. If people don't know, they can't utilize education. They can't utilize the information. They don't know who to go to. It falls under the remit of the Integrity Commission. They do have a director for public education. I'm suspecting that hearing all of this conversation, they are going to, within reason and with reason, have some kind of campaign beyond social media. Social media, as I have consistently said, much to the disdain of others, does not reflect or include all Jamaicans. Campaign must be done in all spaces and forms that facilitate people understanding, knowing, and being able to take use of the information. So don't bother tell me if I don't know how to deal with it. Talk to me so I understand what it means. Let me know who I can talk to. Let me know why I must do this. In other words, build a culture of understanding and appreciation for the legislation. Right. And that is something NIA has consistently asked for.
All right. Thank you so much, Ms. Archer. Last word from you, Mr. Wan, because we have to go now, and I know you both have other things doing.
Yes, I think this is a much needed amendment and adjustment to the Act. I don't think it has been very heavily publicized, but I think it needed the amendments that we are seeing now. because it just wasn't being utilized enough. And I think that's the aim of what they're doing right now. How do you get more utilization, make it more effective?
All right. Thank you so much. We appreciate you both. Have a good day.
No problem.
Likewise.
That was
Have a good
Daniel
one.
Archer, Principal Director and Attorney at Law, NIA, and Mr. David Wan, President of Jamaica Employees Federation. We take the break.
Welcome back to Let's Start Justice. We've been talking all things whistleblowing and discussing corruption and human rights violations and the provisions under the Protected Disclosure Act. We were joined previously by Daniel Archer and Mr. David Wan from National Integrity Action and Jamaica Employees Federation, respectively. And we are in our last section of discussion.
Yeah. And we just wanted to ensure that those who are listening in, you understand sufficiently what the provisions are in the Protected Disclosure Act, because we do encourage people to make reports, but you have to know what you can make a report on. And if you make such report, you have to be so guided whether or not you will be so protected. So we're going to just have a quick discussion on what an improper conduct means. So Jade, the person who can see, especially when I have my set of eyes put down, she will outline for you what improper conduct mean as an important starting point.
Right. So under the Act, Section 2, it describes improper conduct as the following actions. A criminal offense, failure to carry out a legal obligation, conduct that is likely to result in a miscarriage of justice, conduct that is likely to threaten the health or safety of a person, conduct that is likely to threaten or damage the environment, conduct that shows gross mismanagement, impropriety, or misconduct in the carrying out of any activity that involves the use of public funds, an act of reprisal or victimization of an employee, conduct that tends to show unfair discrimination on the basis of gender, race, place of origin, social class, color, religion, or political opinion, or willful concealment of any of the acts described previously.
So if you see nobody hiding the information based on all of the issues earlier, you can say that this is something that I should or I can make a report on. So that's the first thing. We also want to be clear that the Protected Disclosure Act, it allows for internal whistleblowing. So in other words, when you're blowing the whistle, you have to be looking at those internal channels that exist. So within your workplace, so you blow the whistle perhaps to a supervisor within your entity or to an entity based on the issue. The only time an external whistleblowing is possible is within the context of the agencies that the Act outlines as prescribed authorities. So in other words, if you see a particular improper conduct, for example, something relating to the environment, you may ask the question, who do I blow the whistle to? If you're uncertain, then you can make a call directly to the Integrity Commission, that is the designated authority.
Right.
You will receive no protection if you call Jamaicans for Justice. As attorneys, however, we're not a law firm, but we have lawyers in the office. You can be protected if you seek legal advice from us or any other lawyer. There is that provision in the Protected Disclosure Act, and we can so guide you what the provisions of the law entail and guide you to the right person. But if you're making a disclosure to Jamaicans for Justice, the advocacy organization, then you are not so protected. If you go to the media, you are not so protected. JFJ has a proposal on this, and I know it was debated in 2010 thereabout. The leader of the opposition, Mark Golding, at the time had cautioned the committee against that. So I don't know where the parliamentary opposition stands on this particular issue. So when we go back before the Joint Select Committee, Jade, I expect some pushback here, but I think we stand ready in terms of our justification for that. Yeah?
Yes.
And there are some other things, Jay, that the law protects people. And we mentioned occupational detriment. You want to speak quickly to that?
Yes, so when we speak about occupational detriment, it is basically allowing for you not to have your career impacted by the fact that you have made a protected disclosure. Now, an occupational detriment is defined as being subject to disciplinary action, being dismissed, suspended, or demoted, being harassed, intimidated, or victimized, transferred against your will, refused a transfer or a promotion, subject to a term or condition of employment or retirement that it is altered to your disadvantage, you're provided with adverse references, you're denied appointment to any provision or office, you're threatened by any of those actions, so your employer threatens you with any of those actions, or you are otherwise adversely affected in respect of your employment, profession, or office, including opportunities and the security of your job. And it would be considered an occupational detriment if it is that you encounter any of these actions soon after you have made a protected disclosure.
Now, you're listening in. Two things to note. You are protected, not your child, not your mother, your father, the persons in your household. You are protected. You will also recognize that it speaks to occupational detriment. So within the context of the workplace, but we know reality no set so. So in other words, what JFJ is proposing, and again, when we go before the Joint Select Committee, we would articulate that because we didn't get to that part of the proposal. We're saying that the law ought to broaden in scope, move it from occupational detriment to detrimental action.
Yes.
Because we realize harm may come your way, including threat to your life, including threat to your child's life. So depending on the level of improper conduct that you're disclosing on,
Yes.
for lack of a better term, right? So I just want to put that in context that the law has some provisions and protections in it, but based on our context, sociocultural norms, in form of a debt, the possibility of real threat coming to us, we're saying, one, broaden it outside of the workplace, but also ensure that for those who are close to us, so in other words, if they can't catch me, they may catch somebody close to me.
Yes.
There ought to be some protection there. There are some other things, Jade, but, you know, one of the things as well, you mentioned it, allow for anonymous reporting. We spoke extensively about the incentivized reporting. I think that is clear.
Yes.
But outside of those things, so I don't want to go too much in our proposal because we want to have something to talk about before the Joint Select Committee.
Sure.
One of the biggest gaps for me is the lack of regulations that accompany the protected disclosure. As usual, I read and I don't remember where I read stuff. But there was another country that I looked at, and I'll find it back before we go before the Joint Select Committee. And basically, it outlines in a table a schedule that could accompany the legislation to say, it breaks down the improper conduct by saying these are possible actions, right? And then it says these are the entities that would be best suited. So in other words, Michael Jackson don't need, as a non-lawyer, go read through what Section 2 entail. It will be incumbent on the Integrity Commission and the other agencies to say that this is the work that I do. These are the matters that I govern.
Yes.
And if you are making a protected disclosure in these particular issues, my agency is the best agency suited to receive that information. So the regulations would outline that in a very practical ways. So even the non-lawyer, because this is the problem I have, we have too much laws being passed and nobody can read them to the point where you go before Joint Select Committee and you have to be saying what the law say again. And these are learned people, as attorneys call themselves, learned, not learned. Right? So we don't look at these things, Jay. The question is, there should be a schedule that the person can pick up.
Yes, and I think that was, as you said, one of the gaps, because we did put all of the agencies in the schedule, so we could have simply aligned with those agencies.
Possible actions,
yes.
You know, you call Indicom, you know, you call this, you know.
And you'd be aware that it's not a closed list, so you just know the kinds of matters that you need to bring to each agency. And I think that, as you said, it would incentivize greater reporting.
Because, you know, when we look at the Jamaica Constabulary Force and the impact they've managed to make in recent times in terms of the number of reports coming in, whether people are incentivized or not, and the incentive may very well be non-monetary, but just that need to get Jamaica to a particular point. It needs public education. And as Daniel rightly said, public education is not on social media that only 48% of Jamaicans have access to internet. We have to go in the communities. So I know Integrity Commission has some plans based on previous discussions with the body. So, I just think it needs to be done.
Yes.
While the act is being reviewed.
I agree. And it will be useful for the review process, I think, if it is done within a timely enough manner before the report is produced.
Yes.
Okay, so we are basically at the end of the show. We do have a winner for our trivia question this week. The answer is 2001. The question was, what year marked the inception of the Witness Protection Program in Jamaica? So since 2001, we've been able to put persons in protective custody while they give evidence in court. And our winner for this week was Beauty Kim, 1876. So you will receive your prize via Instagram later on today. Thank you so much for participating.
We have 30 seconds left, Jade.
Yes.
And before we close out, I want to say we need to do a program on the Witness Protection Program, an episode.
Absolutely.
Because you saw they come in from the DPP this morning to say a number of witnesses are recanting. I think we need to probe the why.
Yes.
As we ventilate the matter. So I'm not sure if Minister Chuck may be so guided and receptive to coming on the program right before going to Parliament.
We'll certainly invite him.
Yes.
So thank you so much for joining us. We will be back next week, same time at 1 p.m. I am Jade Williams, Policy and Advocacy Specialist at JFJ.
And I'm Michael Jackson, Executive Director. Thank you so much for joining us.